Hi, welcome everyone. My name is Lynette Martins. I'm here with Scott Schweikart to speak with Professor Valerie Gutmann-Koch about crisis standards of care and liability shields for providers. For those of you tuning in from Canada, happy Canada Day. And those of you in our affinity group may remember a few years ago, of course, that Professor Gutmann-Koch and Professor Nadia Sawicki chaired this law and bioethics affinity group. One of the things that they proposed was for us to develop a webinar such as this. So this is really the seed that they planted, and we are grateful for their mentorship and guidance throughout these years. Thank you to those of you who've sent in questions beforehand. You will likely have questions as we move along, so please feel free to use that Q&A tool to communicate. I'm going to briefly just highlight a few of the forthcoming webinars. Next week, July 8th, we'll be talking with Professor Govind Persad, University of Denver Sturm College of Law, about immunity-based licenses, also known as immunity passports. Something on our minds as we continue our states to reopen, and a lot of places of employment contemplate how the new normal is going to look. July 15th, Professor Kate Spector-Baghdadi will be discussing COVID-19 research, law, and ethics, and following her, a terrific lineup of panelists as well, with dates to be confirmed. So if you're just joining us, we're getting ready to speak with Professor Valerie Gutmann-Koch, who, might I add, needs no introduction, but I will say briefly, she's the Assistant Professor and Co-Director of the Law and Policy Institute at the University of Houston Law Center, and the Director of Law and Ethics at the McLean Center for Clinical Medical Ethics at the University of Chicago. Formerly, she was the Senior Attorney and Special Advisor to the New York State Task Force for Life and the Law, the state's Bioethics Commission, during the promulgation of its ventilator allocation guidelines. We'd like to congratulate her on her appointment to the University of Houston Law Center. So welcome, Professor Gutmann, and many thanks for being here.
Thank you both for arranging this, for putting this together. You know, obviously these are unfortunate circumstances to be doing this, but I'm so glad to see this idea sort of come to fruition and to be able to communicate and you know, and exchange ideas with the Law Affinity Group throughout the year rather than just on an annual basis. So congratulations to you both for putting this together, and thank you for inviting me. So I'll get started. My first major disclaimer is that while I do legal research and write on the law, of course, and I say this to my fellows every year at the McLean Center too, I'm nobody's lawyer, so please do not construe anything I say today as legal advice, but I'm happy to talk about law and policy at sort of a broad level as far as what's happening at the state, federal, and institutional level with regard to liability, especially during the pandemic. Let's make sure my slides are working. So the COVID-19 pandemic has overwhelmed many US systems, including the already strained medical system. And these systems are intended to protect and care for its citizens. Hospitals, healthcare providers, policymakers, they've all begun to face a rather bleak reality that there may not be sufficient resources for all patients who need them, despite hospitals practicing surge capacity or canceling and postponing elective surgeries and procedures. Across the country, alarms continue to be raised about the potential for insufficient equipment and staff, including ventilators and dialysis machines, personal protective equipment, necessary drugs or vaccines, and particularly trained individuals who are able to operate the equipment and treat patients. So in response to the very real possibility that there will be insufficient resources to properly respond to the COVID-19 pandemic, and healthcare providers will be forced to provide a different level of care than under non-emergency circumstances, states have begun developing crisis standards of care plans. Apologies for the dog. I'm gonna let her out. Is that okay? Sorry, guys. I'm gonna take one quick pause and let her out. Ready to come. Out. Good girl. Hopefully.
Love dogs.
You best laid plan. Again, I'm so sorry. All right, I'm going to keep going and hope for the best. Okay, so in response to this, to the very real possibility that there are going to be insufficient resources to respond, these states have started to develop crisis standards of care, which often authorize the prioritization of patients for scarce resources based on changing circumstances and increased demands. They provide a mechanism often for reallocating staff, facilities, and supplies to those that need it during a public health emergency. So in my work, let's see, actually it'll be here. I've surveyed crisis standards of care across the country. So the dark blue states in this map represent those that have written crisis standards of care that have been implemented, or can be, I should say. None have been implemented except for Arizona as of yesterday. The dark blue states are those that have written plans that could be implemented or triggered or operationalized, lots of terms that are being thrown around about what that actually means, during a public health emergency. The light blue states on this map represent crisis standards of care that have been proposed by state hospital associations or others. Despite the significant variation between all of these plans, they are often based on the principle of saving the most lives possible. As a general rule, they focus on allocating scarce resources solely on clinical medical criteria in an effort to avoid making decisions based on things like race, age, gender, or other social criteria. Overall, these plans should be made ethically, fairly, and transparently in order to ensure public trust in the plans. In most instances, these triage protocols are not binding law. Rather, they're state-level guidance that the governor can trigger at the time of or after a declaration of emergency. Thus far, again, states have not had to trigger or operationalize these crisis standards of care, and generally it's considered to be sort of a last resort to have to trigger these plans because they do involve really difficult decision making and patients potentially being harmed based on the decisions that have to be made. Again, Arizona is the first state as of yesterday to have triggered its plan. This is a graphic that appeared in JAMA last week in an article that surveyed ventilator-specific allocation protocols across the country. So it's fewer protocols because these are ventilator specific. But I think that it's a very interesting article that I do recommend to you. It demonstrates, I think, that scarce resource allocation protocols vary tremendously from state to state, even when they're dealing with a specific machine or resource. So in a non-crisis setting, the prevailing medical standard of care focuses on the needs of each individual patient, and it's centered on the principle of informed consent. While the exact language varies across jurisdictions under normal non-emergency circumstances, physicians or surgeons are expected to exercise, quote, the degree of care and skill that a physician or surgeon of the same medical specialty would use under similar circumstances. That's Black's Law Dictionary. But the conditions of a public health emergency directly affects the dynamic of the doctor-patient relationship as it normally exists in non-emergency circumstances. Due to the dearth of necessary resources and trained professionals during a public health emergency, the standard of care that clinicians may be able to provide during the COVID-19 pandemic may, by necessity, depart significantly from standard non-emergency medical practice. During a public health emergency, non-emergency medical care may be impossible or inadvisable due to 1, resource allocation limitations, and 2, the goal of saving the most lives possible. So due to the shifting standard of care during the necessitated by the pandemic, clinicians, healthcare providers, institutions, and policymakers have all expressed concern about potential legal liability for following crisis standards of care. Most states have protections in place for unpaid volunteers who provide care during a declared emergency. However, non-volunteer clinicians, nurses, and other healthcare providers may be hesitant to conform to crisis standards of care, despite their significant public health goals, due to concerns about liability arising from injury or death. So adhering to crisis standards of care may expose healthcare providers and entities to considerable costs and burdens, including the risk of both civil and criminal liability. For example, healthcare workers are taking on significant risk running codes on patient with COVID-19, often without adequate personal protective equipment. Calls for fair treatment of healthcare providers have led to state support for immunity provisions for those who sacrifice their own well-being in service of the public good. Thus, a healthcare provider may risk lawsuits, financial penalties, or jail time, higher medical malpractice insurance rates, and damages to one's own reputation. So these concerns are particularly acute where crisis standards of care recommend certain things like ventilator withdrawal without patient consent. Some commentators have in fact asserted that there may be a legal distinction between withholding and withdrawing life-sustaining treatments or therapies such as ventilators, despite the ethical argument that there is no such distinction. But they have noted that, that there might be a potential for increased liability concerns with withdrawing of care. So in my research, I've looked at what states have done with regard to these liability protections. And I've found that there's a significant variation among states regarding if and how legal liability protections may be provided to physicians, nurses, physician assistants, and other healthcare providers who provide medical care during a public health emergency. Importantly, there is no uniform protection that exists for the provision of care under disaster circumstances or pursuant to state allocation guidelines. Various laws provide different levels of protection. Some laws provide civil liability immunity. Some provide both civil and criminal protections, and some states provide neither. Further, some liability protections are ensured legislatively through general laws that protect clinicians and other healthcare providers from legal liability, absent willful acts or gross negligence, when they provide care pursuant to state directives or crisis standards of care. Other states have issued executive orders or rules that are to be followed during the pendency of the pandemic. These are issued by the governor, and they generally have defined expiration dates, either a date written into the law itself or that terminate at the termination of a declared emergency. So as of June 30, 2020, so as of yesterday, 37 states provide, at least 37 states, provide some sort of civil liability protections for physicians who provide care during a public health emergency. Prior to the COVID-19 pandemic, many states already had legal rules or guidance regarding malpractice liability protections for care that was provided during a public health emergency. Those laws were already in place. So those states that had pre-existing liability protections for care provided during a pandemic are represented by the light blue shade on this map. Of the 37 states that provide liability shields to healthcare providers, 22 states had promulgated new protections specifically in response to the COVID-19 pandemic. 17 of those 22 states, the one shaded darker blue, adopted legal liability protections through executive orders. So that those are those directives by the governor that carry the force of law. The remaining crosshatched states on this map have passed legislation in the wake of COVID-19. Importantly, all applicable laws, every single one of them that provide civil immunity for providing medical care during the emergency do so conditionally. So that means that if a physician has engaged in each law, the language is different, so I can't make huge broad statements about that. But generally, if the physician has engaged in willful or intentional misconduct gross negligence, recklessness, or has provided care in the absence of good faith, the physician would still then be subject to civil liability. And only 3 states, oops, sorry, I was on the wrong slide. So this is the slide that shows the dark blue, light blue, and crosshatch states. I'll sit here for 1 second so you guys can see it. So the crosshatch states are those that passed COVID-19 related legislation since the pandemic began. The dark blue states are those that have issued executive orders, and the light blue states are those that have pre-existing liability protections on the books to protect, to confer some sort of liability protections on healthcare providers who provide care during a public health emergency generally. So this is the one that I was trying to say. This is the 3 states. These are Maryland, New York, and New Jersey. And these 3 states provide protection to physicians for criminal liability that may result during the public health emergency. So civil liability protections also vary significantly regarding the types of actions that are being protected. So we have these 37 states, but they're not all protecting the same sort of behavior. Some states' liability shields immunize injury or death that occurs specifically when the healthcare provider complies with federal, state, local, or institutional plans, guidance, or crisis standards of care. So for example, I'll give a few. Minnesota's law provides immunity to healthcare providers if the negligence occurred while the healthcare provider was, quote, acting consistent with emergency plans. Wisconsin immunizes healthcare professionals providing services during the state of emergency, consistent with 1, any direction, guidance, recommendations, or other statement made by a federal, state, or local official to address or respond, or in response to the emergency or declaration, or 2, any guidance published by the Department of Health Services, the Federal Department of Health and Human Services, or any division or agency of the federal government, Department of Health and Human Services. Similarly, Colorado's law is tailored to actions taken in compliance with state crisis standards of care or pandemic-related guidance. These cover harms that occur when the healthcare provider has, quote, complied completely with Board of Health rules regarding the emergency epidemic and with executive orders regarding the disaster emergency. So this law is narrow in the sense that it only covers actions taken in compliance with emergency state rules, although it seems to provide liability protections for healthcare providers who negligently care for both COVID-19 patients and non-COVID-19 patients. Some states limit their liability shields to negligent care of patients specifically diagnosed with COVID-19, for whom the standard of care may be modified due to the pandemic. Pennsylvania, for example, grants immunity to healthcare providers, quote, engaged in disaster service activities, but only for COVID-19 related medical and health treatment or services. Rhode Island's executive order from April 10th explicitly states that its law provides no immunity for negligence that occurs in the course of providing patient care to patients without COVID-19, whose care has not been altered by the existence of the disaster emergency. Kentucky has also narrowly drafted its immunity conferring provisions, restricting its protections only to negligent care of patients diagnosed with COVID-19, and then clarifying the types of action the law contemplates. But in contrast, many other states provide much broader civil liability protections. These laws ostensibly cover any harm to patients, irrespective of COVID-19 diagnosis or treatment, as long as the healthcare provider's actions were, quote, in support of the state's response to the pandemic. So in other words, the healthcare provider's actions needn't be in accordance with a specific crisis standard of care or guidelines to be protected. So these laws could be interpreted to apply to really any negligent care that occurs, regardless of whether it's due to scarce resources or whether the provider is specifically following a crisis standard of care. So many states have also instituted liability protections for institutions, such as hospitals, nursing homes, other long-term health facilities. And these are represented by the light blue shading on this map. More states have passed laws, either by legislation or executive order, that provide liability shields for institutions who provide negligent care during the COVID-19 pandemic. And those are the ones represented by the darker blue states. Institutional protections are much more prevalent today than they were before the COVID-19 pandemic began. Although institutional liability protections certainly are not novel to the circumstances of the COVID-19 pandemic. Some states did, in fact, extend civil liability protections to nursing homes and other facilities before 2020, including, for example, Indiana, Iowa, Minnesota, and Virginia. And just like with civil liability protections for healthcare professionals who provide care during the pandemic, almost without exception, state civil immunity provisions for healthcare institutions exclude willful or intentional misconduct, gross negligence, recklessness, or the provision of care in the absence of good faith. Further, New York and New Jersey have extended criminal immunity to healthcare facilities that provide care during the pandemic. However, many states will still only provide liability shields to healthcare providers and not institutions. So as you can see here, while many state statutes that were enacted before 2020 only provided civil immunity to healthcare providers and not institutions, interestingly, almost half of the laws and executive orders that have been promulgated specifically in response to the COVID-19 pandemic have granted liability protections to both individuals and institutions. So in response to the COVID-19 pandemic, a few states initially provided liability shields only to healthcare providers, only to later amend their rules to grant similar liability protections to healthcare institutions. So for example, until 2020, Wyoming provided immunity from liability to healthcare providers and other persons who respond to the public health emergency. On May 20th, in response to the COVID-19 pandemic, the state amended its existing laws, adding business entities to those covered by the provision. New York made similar adjustments to its laws, and many other states did as well. So that's the lay of the land, and here's where I get a little normative. So I argue that liability protections are most appropriate in instances where healthcare providers, so these included but not limited to physicians, surgeons, nurse practitioners, nurses, physician's assistants, etc., and in limited circumstances, hospitals and other healthcare institutions, when they follow in good faith state crisis standards of care or local standards of care or federal. Immunity provisions are appropriate when care is provided pursuant, again, to these local, state, or federal rules, guidance, or protocols that are modified from the norm and necessitated by emergency circumstances. So we should determine liability protections based on, one, whether the federal government, state government, local government, professional society, or medical institution has provided rules, guidance, or crisis standards of care, elucidating the modifications to the existing standard of care required during the state of emergency. And two, there is an identified need to extend legal protections to providers or institutions based on perceived reluctance to follow these rules or guidance that are intended to save the most lives, and the reluctance is due to a fear of liability. So in other words, liability protections, I believe, are only really appropriate when providers are providing care pursuant to rules, guidance, or protocols intended to respond to circumstances of the emergency. Blanket provisions, on the other hand, that provide, for example, nursing home immunity, I believe are inappropriate, and I'll talk about that why in a moment. So I realize that this proposal is much narrower than what many states and some other policymakers have proposed, but I believe it's the most likely to ensure accountability and protect vulnerable patients. So importantly, and this is just a handful, many or a select few, many legal experts agree that the common law legal standard of care is adaptable to changing circumstances. And so it would therefore adjust to the needs of medical care in a pandemic. The standard of care is by necessity flexible. So it's technically unnecessary to provide immunity for good faith decisions made by institutions or healthcare providers who provide care during the pandemic. So we're not leaving these institutions and healthcare providers flying in the wind by not conferring special immunity during the pandemic for actions then that would be taken in good faith according to this sort of modified standard of care. Rather, and I argue here with my colleagues as well, activating and publicizing pandemic response plans and crisis standards of care, which authorize the prioritization of patients for scarce resources based on capacity and their ability to benefit from treatment, may be sufficient to provide legal protections for those who follow the guidelines. Despite the relative consensus regarding the legal protections afforded by triggering or operationalizing a crisis standard of care, those who provide medical care on the front lines of a public health emergency might remain concerned about deviating from the non-emergency standard of care. Consequently, the intention behind immunity provisions for healthcare providers who administer care during the pandemic would be to encourage frontline healthcare providers, when confronted with difficult or seemingly impossible decisions, to do their best during the worst of circumstances. Despite the fact that immunity provisions may not be technically required to protect providers who provide medical care pursuant to crisis standards of care during a public health emergency, local governments should work to alleviate doctors and other healthcare providers' uncertainty about malpractice liability when providing appropriate medical care to patients during the COVID-19 pandemic. Not only will laws that provide liability protections potentially encourage adherence to crisis standards of care, thereby resulting, hopefully, in more lives saved, we also owe a responsibility to those physicians, nurses, and other healthcare providers who risk their own health and lives to save others. Protecting healthcare providers from legal liability will ostensibly result in them being more likely to follow crisis standards of care and save the most lives possible without fear of punishment for doing so. However, calls for immunity provisions in order to encourage providers and institutions to follow crisis standards of care in emergency circumstances and save lives. These are being co-opted by politicians and lobbying groups in an effort to extend legal immunity to those who would potentially provide substandard care. Immunity provisions for nursing homes and other institutions have been embraced by some proponents as an extension of protections for frontline heroes in the fight against COVID-19. For example, in late April, as the slide shows, Senator Mitch McConnell made headlines announcing that he would not support the federal stimulus package if Congress did not include liability protections against COVID-related suits for businesses, including nursing homes. But the justification of encouraging good medical decisions pursuant to crisis standards of care is not served by the broad provisions contained in many state laws that provide immunity for all care. So, advocacy groups, patients' rights advocates, and others have argued that extending liability protections to long care facilities, including nursing homes, which account for somewhere between 40 and 50% of all coronavirus-related deaths, is at best ill-advised and at worst deadly. Generally, immunity provisions for nursing homes are not directed at encouraging providers to follow specific state guidelines or crisis standards of care in a public health emergency in order to save the most lives. Rather, they provide blanket provisions to institutions who are already struggling to adequately serve their residents due to, as one recent Health Affairs article put it, years of neglect and chronic underfunding. Even before the COVID-19 pandemic, many nursing homes did not meet, quote, basic health, safety, and staffing standards. Nursing homes have historically and continuously lobbied for liability shields, even under non-emergency circumstances. New liability shields may immunize institutions from ongoing negligent actions that may have even begun before the pandemic began. And during the pandemic, broad institutional immunity provisions remove the last line of protections for residents due to scarce resources and the need to ease some restrictions during emergency circumstances. Some states have already eased institutional oversight. So inspections and other oversight mechanisms have been suspended during the pandemic, and visitors have been restricted during the pandemic, and therefore family members and friends are unable to check in and hold facilities responsible or accountable if things appear improper, resulting in little to no institutional accountability and eliminating any deterrent effect the law might have. So back to my proposal. Oh, that keeps going. So this is an example of all the various articles and op-eds and arguments against nursing home immunity, or shedding light on the inability for nursing homes to provide adequate care, or how many deaths have actually occurred within the nursing homes during COVID-19. So back to my proposal, immunity provisions are really only appropriate based on all this when they're intended to encourage adherence to institutional or state or federal or local guidelines that depart from ordinary standards of care but are intended to save lives. I recognize again that this proposal may not provide immunity to healthcare providers or institutions in circumstances where they are simply overwhelmed by the number of cases presenting at a given moment. But the state has not provided in those cases guidelines or rules for addressing that particular situation. In those circumstances, the inherent flexibility of the standard of care should sufficiently protect providers and institutions who do their best in the worst of situations from liability, while also allowing patients and their loved ones to seek recourse for injuries or deaths that occur due to poor decision-making. So blanket immunity conferring laws that provide liability shields for decisions that may have no connection to resource allocation due to COVID-19, but rather may simply provide an institution or individual healthcare provider immunity from behaving negligently, are inappropriate. In such cases, I argue, immunity provisions remove the last thing that keeps institutions accountable. And with that, I think we can go on to questions. Thank you so much, and I look forward to discussing these issues with you. Scott, you're muted.
Sorry about that, I'm muted. Thank you so much, Valerie. Sorry about that. I have one question to start off with. Do you think a lot of these immunity provisions that are being passed, do you think it's just out of just an abundance of caution, or do you think there is this fear practitioners have of being held liable, so they feel the need to pass these laws? Like, what is the impetus for it? Or is it also just there is this lobbying group from these institutions that want to get these things passed? What's driving it, do you think?
I think at the institutional level, there's absolutely there's money there. There's concern about that type. So if there's money, there's lobbying, right. And so that's happening definitely at the institutional level. There have been exposés in Illinois and New York and other states where institutional liability protections have been passed specifically that protect nursing homes and other long-term care facilities, sort of at a wholesale level. And those exposés have really shown sort of who's driving those laws to be passed, often pointing to hospital association, other lobbying groups, and nursing home groups. From the individual level, that's an interesting question, because there is generally, when I was working on the task force guidelines in 2015, those are specific to New York allocation of ventilators in the state. We focused, there was sort of assumed that physicians and other healthcare providers would be reluctant to provide medical care pursuant to a crisis standard of care, so to treat their patients differently than they would under normal circumstances, based on fear of liability. And in my research, I've actually, since then, have not actually found any empirical evidence of that. So this is an assumption that a lot of us are making, and there's a lot of anecdotal evidence and a lot of quotes from healthcare providers and others that have said, we would be reluctant to do this, but we don't have a lot of empirical evidence. And that's one of the things that we're hoping I and some colleagues to focus on in the future, is looking at, whether these guidelines actually would change behavior, and whether immunity actually changes behavior. Because it is a very, again, we hear stories, but whether, these immunity provisions are really would be as effective in encouraging wholesale adherence is still, I think, up in the air.
Great. I have another question here from you from the group here. Do the immunity provisions simply leave open the argument that negligence is a matter of opinion and thus leave open lawsuits?
I'm sorry, and what was the last?
Yeah. Let me read this again. Do the immunity provisions simply leave open the argument that negligence is a matter of opinion and thus leave open the, I guess, the ability to have lawsuits?
So these immunity provisions, in theory, would block the opportunity to bring suit. But, it does raise, there's so much scholarship about what the negligence standard is. Within the law, jurisdictionally, it differs depending on where you are, as far as if you're looking at, what the standard of care is within various, whether you're looking at the standard of care in the community or across the entire nation. And again, circumstances are supposed to affect what that crisis standard, or the standard of care generally is. So I wouldn't say it's a matter of opinion, but it is incredibly fact specific. All of these cases, every malpractice case, every negligence case is going to be incredibly fact specific. It's also going to depend on the kinds of records that are being kept, what the experts argue or claim during a trial and in their briefings. So there's a lot of, again, these nuanced facts that go into the outcome of every negligence or malpractice case anyway. What I think these laws are intended to do is to sort of wipe out at least some level of negligence claims altogether, so you don't have that that question of whether there should be a lawsuit or not. That's just it would essentially bar a handful or to a majority, depending on sort of the jurisdiction and the law, of negligence claims in the state. Even that all said, we are seeing that there's going to be claims brought. There's going to be arguments, and there are already some arguments that some of these laws are unconstitutional at the state level, or went beyond the authority of the governor to do whatever it is that he or she did. So there are those arguments that are being made, and there are also going to be folks that are going to bring class action and individual negligence claims regardless of these laws in order to try to knock them down, or to argue that, in fact, what occurred was not done, it was not actions taken in good faith. It was not simple negligence. In fact, what happened was gross negligence or recklessness, or one of the conditions that are excluded from most of these laws.
Okay, I have another question here for you. If states do not provide clear guidance for crisis standards of care, how does that impact the range of appropriate actions and decisions a healthcare provider may take? And then they comment, leaving clinicians to make decisions on an ad hoc basis in a crisis. For example, ventilator triage is arguably not the best approach to optimize fair and equitable decisions. Do you have thoughts on that?
Absolutely. One of the reasons, I can use New York as an example. One of the reasons we did the work we did, it started in 2007 with the first issue of the draft guidelines. We redid it in 2000, that were issued in 2015. One of the reasons we took the time to really deliberate these guidelines, they were issued for notice and public comment, despite, they don't have to be by law, but we wanted the public input. We did tabletops, we did public outreach in order to understand what the public was thinking, what institutions were concerned about, what providers were concerned about, in order to put together the most cohesive, coherent, and acceptable plan at the time. That said, I'm not saying that the New York guidelines are perfect. There are lots of things about those guidelines that have that have been challenged since then. For example, since the COVID-19 pandemic began, there's been a lot of talk about not about exclusion criteria, which are sort of that first level that the task force guidelines recommend, where before the clinical scoring system is applied, certain patients with certain clinical conditions that would render them probably almost not just unlikely, but they would not benefit from ventilator therapy, would then be excluded from the triage protocol. And since then, others have argued, for example, Doug White and his guidelines that have been adopted by other states that came out of Pitt, those guidelines, for example, have eliminated exclusion criteria wholesale. And now all patients who present, who might need ventilator therapy or would appear to need ventilator therapy, are immediately put into the allocation protocol, or the protocol applies evenly to all of them. And the argument is that the exclusion criteria, despite efforts at trying to ensure full, only based on clinical elements, that those still involve underlying discriminatory effect. So again, New York, not perfect, but thoughtful and deliberative. And when the COVID, and again, guidelines, not law. So the idea was that in a pandemic, in circumstances like this, the state could look at those guidelines, which the DOH had signed on to in the first place, look at those guidelines and decide how they could be adapted to the changing circumstances of that particular pandemic, and then tell hospitals and institutions and providers, we don't want you to have to apply this. We're going to do everything we can to ensure you have enough resources. We're going to make sure that we exercise surge capacity and allocate ventilators across the state equitably so that everybody's getting them in the way they need to, and do everything we can so you don't actually have to use them. But in a worst case scenario, and we're in a situation where we just don't have enough ventilators, for example, here are the guidelines that we think you should apply. And these are the guidelines that if you follow them, there will be immunity for following them. And had the state done that, I think there would have been a lot more consistency, a lot less struggling and last minute, shuffling by institutions to try to figure out what they would do on an ad hoc basis in the moment, because the state, because, for example, Governor Cuomo specifically said when asked about the guidelines, we have no plan. Now the institutions are sort of left to their own devices, and that meant a lot of inconsistency if they were instituted across institutions, and a lot of moral distress, I think, for institutions and individual providers. So I am really in favor of states being deliberative, and institutions or whomever being really deliberative about these policies in advance, educating their providers across the board about how triage, how resource allocation, how the standard of care, how care is going to look in these circumstances, and essentially say, we've got your back if you follow these, because we do want to avoid this ad hoc behavior that's occurred and probably will continue to occur without I don't want to say activation of, but operationalizing of these crisis standards of care.
Mm-hmm. Mm-hmm. I have another question for you. What do you mean by affording protection for following crisis standards of care? The standard of care shouldn't change. Is that right?
Mm-hmm. Exactly. So the crisis, actually not exactly. The crisis, the standard of care in medicine does shift according to circumstances. It's inherently adaptable. and within the law. And that's sort of that slide of the various scholars that have talked about this. And generally, if you are doing, if a physician, healthcare provider, et cetera, institution is providing care in good faith according to the standard of care as circumstances demand it, they should be protected from negligence. It doesn't mean that a negligence claim isn't going to be brought against them, but at the end of the day, they should be able to prevail. What these immunity conferring provisions do is say there are no claims that can be brought generally. You can't bring a claim against a provider who follows the standard of care in this moment. So these crisis standards of care are really just sort of the rules. They're like guidelines. Some have analogized them to clinical practice guidelines, for example, but instead of being about sort of a specific type of procedure or therapy, they're about care provided during these emergency pandemic circumstances. And so the idea is that if you follow those, the state's sort of going above and beyond and saying, we will immunize you. And so my argument again is that generally the law should protect physicians, nurses, other institutions, healthcare providers from liability for providing care in emergency, as long as they're doing it in good faith, without gross negligence, et cetera. But in certain circumstances, I think having these rules that are consistent across institutions across the state is going to encourage better care that's going to save more lives. And then by triggering these immunity provisions, physicians and healthcare providers and institutions are more comfortable following these guidelines, doing something a little bit different from what they're normally used to, because they know that they're protected from liability.
Another question here, does your proposal require that a state trigger the crisis standards of care guidelines before any protections kick in? As you've noted, only Arizona has done that right now. So what's your thought there?
Ideally, yes.
Mm-hmm.
I think that there's arguments that can be made that on an institutional level, even without a crisis standard of care being triggered, and that's why I also talk about, when I go through my list, it seems so long, federal guidelines, state guidelines, local guidelines, institutional rules, because even if the state hasn't triggered a crisis standard of care, if the institution recognizes that they are just in the position where that is, again, last resort, but necessary in order to save the most lives, then I also believe that providers should be protected, that the immunity provision should kick in those circumstances as well.
Mm-hmm. I have a question. You noted in your presentation only like 3 states have talked about criminal liability provisions. Why do you think it's so few versus criminal versus civil? Or do you think that might change? Do you think other states might go in that direction for criminal?
Yeah, I think criminal liability protections are for one, they're difficult to pass. They're a little less, not a little less, they're, I think, quite less politically palatable. Yeah. Generally, criminal liability doesn't really adhere in most of these cases anyway. The case that always comes up again and again about care provided during an emergency in which a criminal claim is brought against a physician. There's like one big one, and that was the physician during Hurricane Katrina. At the end of the day, she was not, I don't even think that case actually saw the inside of a courtroom. I think I'm pretty sure the criminal claim was dropped in that case. And so it's just not really as much of a concern to most providers and institutions that criminal claims are going to be brought against them anyway. The one exception that you can see in some state laws is the question about withdrawing of care. And some folks have recognized or highlighted the fact that, say, withdrawing of a ventilator from a patient who is who would not otherwise be extubated, but for the circumstances of the pandemic, could be considered to be to meet the level of criminal liability that would maybe bring a claim that would be sufficient for a claim against them. And so those are the kinds of things that I think that states might want to think about if they're going to recommend or provide guidelines or rules about, for example, ventilator allocation that includes extubating patients.
Mm-hmm. I have another question here with regards to the disability angle here. Disability rights advocates have appealed to the ADA and other federal legislation to challenge state plans for triage and scarce critical care resources plans. Do state immunity orders and legislation protect against liability for claims in violation of disability rights? So coming from that disability angle.
Yeah, so I mean, the other thing is with state, most of these immunity provisions are talking specifically about negligence, state law, right. And so states don't have the ability to provide immunity from federal claims. Okay. So if there's claims of, under the, those would be a different type of claim that would be brought, and most of the laws are not going to immunize providers and institutions in those ways. And I will put a plug in for next week's speaker, because he has written a lot about disability in triage decisions and these protocols in just the last few months alone. Mm-hmm. So definitely also direct some of these questions to him.
Mm-hmm. Okay. Let's see. I have this question. The failure of states to adequately hold institutions to the routine standards is a separate problem that ought to be addressed. But in the setting of a crisis, wouldn't a gross negligence type of standard of care provide adequate protection to patients while holding institutions to account for their actions?
So would it be gross negligence for, I'm sorry?
Would a gross negligence type of standard of care provide adequate protection to patients while holding institutions to account?
You mean a court, like? So the question, are the laws that provide more blanket immunity for negligence okay because they still exclude gross negligence? Sorry, no, it's probably not your question.
Yeah. Sorry, no, sorry. Look, it's not clear.
I think it's just contemplating if the setting of the crisis would be gross negligence, for instance, in like a skilled nursing facility or long-term care place, to be accountable for their actions.
I see. Okay, so I started thinking hospital institutions. So yeah, so whether nursing homes it would be gross negligence just because of the other actions they're taking. So yes, but gross negligence is very hard to prove. And so, unless you really have a record, and that record is going to be also very difficult to keep, especially because nobody is there keeping records at this point. A lot of the record keeping requirements have actually been suspended during the pandemic. Family members and loved ones are not able to observe what's happening in these nursing homes. We are seeing litigation. We are seeing cases against nursing homes for their actions, both for negligence, gross negligence, as well as recklessness and all the other, depending on the state law and what it requires. But it's sort of important to note that, gross negligence isn't just a more egregious form of negligence. It has its own things, things that you need to prove in order to prevail. And so it's just a much higher bar. And so the argument is that a lot of these actions that are being taken by, unfortunately, not all nursing homes are bad, not all institutions are bad, but in some of these cases, what's happening is simple negligence. It is negligence, and there should be, the patient shouldn't have, and the family members shouldn't have to meet such a high bar in order to recover when what's happening is really, is not actually benefiting anybody. These nursing homes aren't necessarily doing this in order to save lives and protect their residents, but for other purposes and other reasons.
I have another question here. have you thought about parallels to liability waiver shields that are being proposed in other industries as we open up? For example, those being proposed in higher education. There seems to be a shift away from obligations owed by those providing services, many of which are arguably essential to one of personal responsibility and personal assessment of risk.
Right. So, absolutely. There is a lot of overlap when we're looking at liability shields in the healthcare arena to, what's happening at the university and the school levels and waivers there, sports, and then of course employment and the waivers and the assumption of risk that sort of that all of these arguments that are playing out right now, both in the academic literature and on Twitter and out there in the world. So yes, there's absolutely things that can be taken from this into the other sphere and all these other spheres. One of the reasons I focused on healthcare because that's my area of expertise and that's my specialty and where I started and sort of moved from there. Also, because we're looking specifically here at standard of care and negligence within medicine, that relies on this special relationship, this doctor-patient or healthcare patient, provider-patient, or even healthcare institution-patient relationship, and the duties that are conferred by those institutions, by those providers, or by the relationship to the providers, to the institutions. That there's a very different power, well, not a different power dynamic, but it's different. It's not, again, in the employment setting in those, it's not an equal power dynamic either. A lot of employees will feel like they're being forced to sign these waivers and accept this risk in order to provide for their families and for themselves. But that said, within the healthcare setting, it's a different type of power dynamic, it's a different kind of duty that between the doctor and the patient, and the healthcare provider and the patient, and that therefore the standard of care is different. So we're just it's a different concept of what negligence looks like, which is why I'm sort of hesitant to just pick up what I'm talking about here and just sort of drop it on these other settings. But I think there's a lot to learn from the healthcare setting that we can apply in those settings and vice versa. And I think these are questions that we're going to continue thinking about over the course of the next few months, few years. And there's a lot of scholarship. I think it's ripe for discussion.
Lynette, do we have much time left in that, or time left?
I think let's take one more question, and I think we can always continue the discussion or conversation over Twitter or certainly by email. There's a question here about, for crisis standards of care guidelines, how are advanced directive or medical power of attorneys, POLTs, and so on and so forth handled? This is a circumstance where the physician acts directly opposite to the intended patient wishes. Wonder if you could address that.
Yeah, so this is going to be something that comes up pretty frequently. One of, also relatedly, DNRs. That's something that's going to be, that has already started to be addressed and continues to be so. For example, there was a lot of, for a little while, there was some rumbling within some institutions that were trying to figure out the best ways to make triage decisions upon admission. And there was talk at some institutional levels about, for example, unilateral DNR upon admission for all patients, all COVID-19 patients, because of mainly, I believe, because of the risk of intubation and DNR, so DNR, DNI, to the providers, especially with lack of adequate PPE for providers. Most of those, I think, recommendations, at least at a policy level, were sort of scrapped, often based on public reaction to those. That said, there's still talk about DNR in other settings, for example, or situations. For example, there were rumblings about in various states about including DNR on the list of exclusion criteria, that list of clinical criteria that would exclude you from, this is again a very general way to say it, but exclude you from the clinical scoring system that would allocate resource in the next step. So that's that first step of applying exclusion criteria. And again, those are generally supposed to be only clinical criteria. Those that haven't been based on clinical criteria, for example, where they've included age as an exclusion criterion, those exclusion criteria have often have been rescinded or knocked down because they've been challenged by under the ADA and other and non-discrimination acts. So I would argue that, and I've written about this, I think it was on the Hastings Center blog, that DNR, that including DNR on the list of exclusion criteria as discriminatory is not clinical and should not be included on that list. And so my argument, so we're going to see liability. We are going to see, or we're going to see claims based on patient desires and preferences and surrogate preferences being overruled in these cases. And so a lot of it's going to come down to whether there was a chance. I mean, unilateral DNRs do exist on a case-by-case basis out in the real world in the non-emergency circumstances. And those have been challenged and can be challenged. But generally, there's this question of whether providing the care pursuant to the wishes of the patient or the surrogate would actually benefit the patient in any way. And if the answer is no, my guess is under crisis standards of care, where crisis standard of care is actually being implemented because there are not enough resources to go around, that those decisions will be upheld to overrule the patient's preferences. In other cases where there were enough to go around and and the healthcare provider or the institution decides not to follow those preferences, that's where there's going to be a problem.
Great, thank you so much. And lots of great questions coming in. I apologize, we are running low on time, but you can always continue the conversation. Valerie's always willing to engage with you on Twitter. And if you're trying to at her, it's at VGKOCH. And we want to thank her very much for being here and continuing this very important discussion. And next week we'll be next week we'll be speaking with Professor Gutmann-Koch about immunity passports at the same time. So please join us for that very important discussion as well. And we want to, again, congratulate Professor Gutmann-Koch on her many achievements, as many of our speakers have had in the past as well, and continue to stay safe and have a wonderful Independence Day celebration. Thank you all.
Thank you. Thank you so much.